Good afternoon, everyone. My name is Melissa Threadgill, and I lead the policy and implementation team at the Massachusetts Office of the Advocate. I'm pleased that so many folks could join us today for a discussion about juvenile justice system data trends and opportunities for improvement. I have to admit, it always warms my wonky heart when so many folks want to show up and dig into what will be admittedly a slightly nerdy presentation about data, but we are going to do our best to keep it interesting. And I'm also joined here today by my colleague, Christy Palazzano, who's our Senior Policy and Implementation Manager. And she, in addition to other things, leads our juvenile justice work, and she'll be doing the data portion of the presentation. Please do note that we are recording this webinar so we can make it available to folks that weren't able to join it at this particular date and time. And you'll also receive a recording of the webinar along with a copy of the slide deck. And you can feel free to share that with others if you are so excited about what you hear today and you want others to know as well. If you can go ahead and to the next slide, please, Christy. So today we're going to tell you a little bit about the Office of the Child Advocate and the Juvenile Justice Policy and Data Board. I'm then going to turn it over to my colleague, Christy, who's going to talk about fiscal year 24 key data trends. I'm going to come back and talk about opportunities for state improvement and give you a little bit of a foreshadowing of some of the upcoming JPAD and OCA juvenile justice related projects for 2025. And then we'll have some time for question and answer at the end. You should feel welcome to pop any questions you might have in the chat as you go. If it's an easy or straightforward question, we'll have folks monitoring and they'll just go ahead and respond to you immediately. If it's a more complex question or something that requires some discussion, we'll save those for the end. But please, anytime a question comes up, just feel to put that in the chat. Next slide, please. All right, so as I said, I'm from the Office of the Child Advocate. Hopefully, many of you know who we are, but just in case you don't, the OCA is an independent executive branch agency that provides oversight of state services for children. Our mission is to ensure that kids receive appropriate, timely, and high-quality state services, and with a particular focus on making sure that the Commonwealth's most vulnerable and at-risk children have the opportunity to thrive. We do that in a lot of ways. One of the ways we do that work is through policy research, data analysis, and advocacy. And this webinar is part of that project to make sure that folks are aware of what's going on with our juvenile justice system and what opportunities we have to make it better. Next slide. Maybe next slide. There we go. The OCA also operates a complaint line. And we just try to take every chance we have to let folks know about it. Any individual can contact the OCA to express concerns or ask questions or be connected to resources. If you've got a concern about a child who either is receiving state services or should be, please give our team a call. You can call us, you can email us, you can submit a form on our website, but we've got some really experienced clinicians with diverse experience in human services who can help you out. And translation services are available in multiple languages. Next slide, please. All right, this work that we're presenting today comes from the Juvenile Justice Policy and Data Board, which the Office of the Child Advocate chairs. The JPAD is a permanent commission that was created by the legislature in 2018 as part of the Criminal Justice Reform Act. Its members, which is set by statute, consist of representatives, from various child-serving state agencies in the executive and judicial branch. We have members from the House and Senate. We have representatives from advocacy organizations as well as parents. And our job is to study the system, see what's working, what isn't, and make recommendations for improvement. We are tasked with collecting and reporting available juvenile justice system data, which is what we're going to present today. And we're also tasked with studying the implementation of any big changes or new bills that are passed that impact the juvenile justice system. So we can go back to the legislature and say, hey, this part is working great. This part needs some further work. Next slide. So as part of that effort, we've paid particular attention to a couple of bills that have been passed since the JPAD was created. And we're going to be referencing these bills a couple times throughout the presentation. And so I just wanted to give you some background on what they were, just in case you weren't aware of these pieces of legislation. So the first one, the biggie, was passed in 2018. It's the Criminal Justice Reform Act, or the CJRA. This was a large-scale reform that impacted both the adult and juvenile criminal justice systems. But to focus in specifically on the juvenile justice pieces, this bill raised the minimum age of responsibility from 7 to 12. That means that youth younger than the age of 12 are no longer prosecuted in juvenile court. It removed juvenile court jurisdiction for first-time lower-level offenses and allowed judicial diversion pre-arraignment. This was all part of an effort to, whenever possible, keep youth out of the justice system, because we know that justice involvement can have some really negative impacts for kids on their long-term outcomes. And a lot of research on that, and we'll talk about that a little bit. But that was the big push between this bill. And the bill also included some new requirements around school resource officers and overnight arrest lockup procedures. In 2020, the legislature followed it up with the policing reform bill. Again, very large bill, but a couple of pieces that specifically relate to the juvenile justice system. It set up a post commission, police officers standards and training. And among other things, the commission was required to set minimum certification standards in a variety of areas, including juvenile operations. The bill also directed the Department of Elementary and Secondary Education to report on any arrests or citations that happen in school. And it also included some new requirements for school districts to submit MOUs, memorandum of understandings, when they do have a school resource officer. So we'll reference a couple pieces of these bills throughout the presentation. And I think now I'm going to turn it over to Christy, who's going to talk to you about the data.
Thanks, Melissa, and good afternoon, everyone. As Melissa mentioned, my name is Christy Polizano. I'm a Senior Policy and Implementation Manager here at the Office of the Child Advocate, and I have the pleasure of going through the wonky data slides. But as Melissa mentioned, we're going to try to make them fun and really break it down for folks on the call. I see we have a good number of folks joining us today, and so before I dive into the data and the fiscal year 2024 data findings, I wanted to take a step back to make sure we're all entering this conversation with a general high-level SparkNote version overview of what the typical juvenile justice system process looks like in Massachusetts. I say typical because it's not always so linear. Kids, as you'll hear in a couple slides, don't necessarily hit every single one of these points. But I wanted to take a second to go step by step about what a typical process could look like. So we're all using the same terminology for a variety of reasons, but really importantly, because the language we use in the juvenile justice system is intentionally different than the language you might be more familiar with the adult criminal legal system. And that's intentional and important because kids are different. We know that from adolescent development and brain research. We know that from sociological research. We know that because all of us on this call have been kids and also remember what it's like to be kids. And so the juvenile justice system is really separate from the criminal adult system, and the language we use in the system reflects that difference, because we don't want to predetermine a child's adulthood based on the language that we're using. And so try to stick with me through some of these wonky terms. But first, on the process point here is an alleged delinquent offense, which is the first wonky phrase you'll hear. A crime was committed, right? There was an alleged delinquent offense that happened. And the next stage in that process in the juvenile justice system is that there's law enforcement respond. And in the juvenile justice system in Massachusetts, you have law enforcement have two different options in how they respond. They can either respond with an arrest, which is what you might traditionally think of with police. So handcuffs and a police cruiser and youth being taken down to police lockup, things like that. Or they can issue a summons, and a summons says, is mailed to a child's home and says, you're alleged of committing so-and-so offense, and you are required to show up to a specific courthouse on a specific date and time. And importantly, in Massachusetts, police officers are trained to use summons more frequently than arrests, and use arrests only in situations where they are witnessing an alleged delinquent offense take place, and that delinquent offense might threaten public safety, and an officer needs to intervene. or if an officer believes that a youth wouldn't respond to a summons and are at a flight risk and wouldn't show up to the court hearing if a summons was issued. Um, we do that for a variety of reasons. Arrests can be dangerous for not only the youth involved in the arrest, but also police officers. And for kids specifically, can be particularly traumatic. And so we really, in Massachusetts juvenile justice system, tend to defer to summons rather than arrests. Whether or not an arrest or summons take place, the complaint is brought to juvenile court, and court clerks issue something called a delinquency filing if there's probable cause that the alleged delinquent offense happens, and probable cause is a legal threshold that the clerks use. That delinquency filing, prosecutors or assistant district attorneys who work at the district attorney's office will look at that delinquency filing and determine whether to officially charge a youth. And if they determine to charge a youth with an offense, that happens at the arraignment stage, which we're here. And that stage is really important in the juvenile justice system because that's when youth officially have a juvenile court record. After an arraignment, so after youth are formally charged, a variety of things can happen. Youth can be released on something called personal recognizance, and so saying, just show up to court at your next court hearing. They also could be released on pretrial conditions of release and have a probation officer supervise them during this pretrial phase. Or they could be detained pre-trial at a Department of Youth Services, DYS facility, pending their disposition. At the disposition stage, that's when a judge or jury, determines whether the youth is adjudicated delinquent. In adult court, that's found guilty, or adjudicated not delinquent or not guilty. In Massachusetts, there's also something called quaff, continued without a finding, in which youth can say, admit to facts of the case that would lead to either a judge or jury determining that they were adjudicated delinquent. But instead of pleading adjudicated delinquent, they're going to be placed on probation. And if they're successful on probation, their case won't result in that adjudication. If youth are adjudicated delinquent or found guilty, a judge has a couple different sanction options. In adult court, we would call it the sentencing phase. Common sanctions in juvenile court in Massachusetts are sanctioning a youth to probation and probation supervision with specific conditions, or commitments to the Department of Youth Services, which is our juvenile justice agency. Commitments to the DYS are until a youth is 18 years old, typically. And so if youth are committed to the department at 15 years old, they might spend some of that time in a residential or in a placement of DYS, and then the remainder years until they turn 18 in the community. So that is the system in its entirety. And the board really focuses on, and you'll hear this a lot in the data presented, on opportunities for diversion and keeping youth out of the system. As Melissa mentioned, the Criminal Justice Reform Act places an emphasis on trying to limit the number of youth coming into contact with this process here. And that's for good reason. Research shows that diversion is good. Most kids age out of any type of delinquency involvement naturally without any state intervention. And the research really shows that diverting kids away from this traditional court system is better on almost every single measure across the board, including an increase in public safety and a decrease in future arrests or adult system involvement, but on other measures too. So kids who are diverted away from the system have better educational outcomes and perceptions of opportunities. And so the board really takes a lens of trying to make sure that we're using diversion to keep kids out of this process whenever possible, and really focuses on things that are pre-arraignment. So this law enforcement contact and the delinquency filing and complaint stage, because that's before a youth has their juvenile court record. So a couple of data notes. This data looks at fiscal year 24 data. This is state fiscal year data that starts July 1st, 2023 through June 30th, 2024. And in the report and in the slide deck, to the extent we're able to, we get data from a variety of different system actors that make up the juvenile justice system. And when we can, we break down the data by the offense severity and type of offense, as well as any demographic data that we might have. We always also compare fiscal year 24, the current fiscal year data, to changes from last year, fiscal year 23, and to pre-Criminal Justice Reform Act implementation, since that impacted so many had so many juvenile justice system provisions in it. So you'll hear me compare it to last year as well as fiscal year 18. All right, so this is it. These are the 6 key data findings that we have in the fiscal year, or in the 2024 annual report that the board issued last month. I will break down the data for each of these key takeaways, but if you zone out over the data, know that these 6 key takeaways really tell the story of what happened in 2024. So starting with the increase in entries into the juvenile justice system has slowed significantly after a couple years of pretty substantial increases in system use following the COVID-19 pandemic, which we saw all-time lows in system use during that time. This is good news, right? We want to limit the number of youth coming into contact with the juvenile justice system. However, finding number 2 was that the board found that despite this plateau or leveling off effect across most of the system, the use of physical custodial process points is actually increasing. And I'll dive into the data and what that really means, physical custody, in a couple of slides. When we dig into the data around physical custody, we see that this increase is primarily driven by an increase in arrests as well as detention and commitment admissions for lower level, or what we call them, misdemeanor offenses. Finding number 5, the board found that the vast majority of youth held in a locked detention facility, so these are youth held pre-trial, are not found to be dangerous and not ultimately committed to DYS. And the board has, since its inception, really placed an emphasis on racial and ethnic disparities that exist in our system. And fiscal year 24, unfortunately, was no different. And in fact, at key process points throughout the system, racial and ethnic disparities in our system are worsening. And I'll detail that data in a couple of slides. One of the concerns the board had this year was an increase in system use for girls. This was something that hadn't been seen in the data in previous fiscal years, but in fiscal year 24, we saw specific increases and spikes in use for girls in 2024 compared to 2023, and I'll dive into that in just a second. So the good news, like I said, our key finding that the board had in their report issued last month was that this increase in entries to the juvenile justice system has slowed significantly in the last year after 2 years of large increases to system use. So you can see this chart breaks down the process points across the major juvenile justice process points that I just went over with you all. We'll take arraignments here as an example, but they all follow the same trend. So you can see for arraignments in fiscal year 2018, that's this bright blue. After fiscal year 2018, or after Criminal Justice Reform Act was implemented, we saw a big decline in the number of arraignments for each fiscal year, reaching to this light purple here. That's fiscal year 21, or the peak of COVID-19 pandemic, where we saw a concerted effort to keep kids out of the juvenile justice system, and is what we reached our all-time lows. But we really saw an increase in system use post-pandemic for 2 fiscal years. So this light blue here is fiscal year 22, the orange is fiscal year 23, and then last year, fiscal year 24, we saw a leveling out instead of an increase, which is a good. We didn't see that sustained increase. And we saw that, like I said, across most process points. So that's the good news, that the increases that we saw as a result of the COVID-19 pandemic seem to have subsided, except for the use of physical custody. We saw increases in physical custody across 2024. So this chart here breaks down the physical custody process points that exist in Massachusetts juvenile justice system. So arrests, compared to summons, like I spoke about earlier. Saw a 7% increase in use in 2024 compared to 2023. There was a 9% increase in overnight arrest admissions. So these are youth who are arrested and held in lockup until the next court business day, and a judge will determine whether they can be released. Pretrial detention, we saw a 17% increase in admissions for pretrial detention in 2024 compared to 2023, and a 2% increase in first-time commitments to the Department of Youth Services in 2024 compared to 2023. And so we wanted to break down the data a little bit more for you all to see what's going on specifically at the point of arrests and then pretrial detentions. And so looking at arrests, we could see that the use of arrest has been steadily increasing over the past few fiscal years. And importantly, numbers in 2024 actually reached their pre-Criminal Justice Reform Act numbers. And so this chart breaks down a couple different things I want to bring to your attention. And so first thing, the purple bar chart represents the number of arrests that fiscal year, and the blue represents the number of summons that fiscal year. And so you could see in fiscal year 24, this purple chart here, the red dotted line shows that numbers are back to their Criminal Justice Reform Act numbers. But also importantly, you can see each fiscal year up until fiscal year 23, there are more summons each year than there are arrests, which makes sense. How police officers are trained to respond, especially to youth who are alleged of committing offenses. We want to use summons as the default option more so than arrests. But you could see in fiscal year 23, this trend actually reverses. And so fiscal year 23 was the first year since Criminal Justice Reform Act where we saw arrests actually supersede the number of summons. And that trend continued in 2024 because there was a 7% increase in arrests, and summons stayed virtually the same year to year. When we dig into these physical custody increases, we can see that low-level offenses are driving the physical custody rates. So these are less severe misdemeanor, lower-level offenses that are driving the percent change, the change in cases and admissions in 2024. So breaking down this chart a little bit, first over on the left side of your screen is the percent change in arrests for misdemeanors and felonies in fiscal year 24 to 2023. So you might remember me saying that officers are trained to use arrests in situations that might threaten public safety. And that could be one of the reasons why we saw this big increase in arrests in 2024. But when we broke down the data, we could see actually that arrests actually increased at a higher rate for misdemeanor or lower level offenses compared to felony offenses. So there was a 13% increase in arrests for misdemeanors. And while there was an increase in arrests for felony offenses, it was just 4% in an increase for felony offenses. For pretrial detention admissions, we see similar trends of lower level offenses really driving that increase. And so DYS uses something called the grid system that indicates offense severity, with 1 being the less severe offense and 7 being the most severe offense. And then the JPAD board, when we report that out, we report it as low, medium, or high severity offenses. Low-level offenses, just as an example, are shoplifting, vandalism, things like that. They also include offenses like assault and battery, but anything that would result in injury or serious bodily injury, that's a high grid level offense. Any weapons charge, that's a high level offense. And so we saw a 21% increase in lower level offenses for pretrial detention admissions in 2024 compared to 2023. First-time commitments to DYS saw a similar trend, with low-level offenses increasing 16%, and we actually saw a decrease in the number of commitments for high-severity offenses in 2024 compared to 2023. And when we stick on this pretrial phase part of the system for a little bit, we could see that pretrial detention admissions are up, but also pretrial supervision is also up. We saw a big increase in pretrial probation use between 2022 and 2023 is 68%, and the leveling off that existed in 2024. And pretrial detention is this bottom chart here. We did see a 17% increase in detention admissions between 2023 and 2024. And you might be asking if for pretrial detention, even if the increase might be due to offenses that are less serious, but maybe judges determining that youth who are being detained are more dangerous, and that is why detention is necessary. But when we dig into the data, one of the key findings that the board had this year was that the vast majority of youth held in locked detention facilities are not found to be dangerous, and actually not even ultimately committed to the Department of Youth Services. And so this chart breaks down detention admissions in 2024 and the reasons why youth are detained that year. And this bright purple part of the chart here, 130 detention admissions, or about 14%, are the result of something called a 58A hearing that Massachusetts has that offered judges the opportunity to decide whether youth are deemed dangerous and too dangerous to themselves or others to be released into the community, or if they need to be detained as a result of that dangerousness. And we can see that 14% of youth who are detained to DYS in 2024 are detained as a result of one of those hearings. What that means is that 86% of detention admissions in 2024 were a result of something other than a detention hearing. So youth were detained pre-trial for some other reason. And some of those reasons, for example, you can see the blue part here, 25% of detention admissions were for youth who are held on cash bail. Cash bail is intended to be used to prevent flight risk. So it's used to make sure kids come back for their court hearing in order to get their money. But if you can't post your cash bail, you're detained pre-trial. And 25% of detention admissions in 2024 were for youth who were detained as a result of that cash bail being set. You could see the most frequent reason why youth are detained in 2024, this red bar chart here, or red part of the chart, excuse me, is 35% of detention admissions were a result of bail or personal recognizance being revoked. So if you remember, at this pretrial phase, judges after an arraignment have the option to release youth on their personal recognizance or place them on conditions of release, or one of the options is setting bail. And if youth violate those conditions of release, their bail can be revoked. And so they have many of the detention and admissions in 2024 are a result of youth whose bail has been revoked. This last data point down here, in 2024, 87% of pretrial detention admissions didn't result in a commitment. So that could be for a variety of reasons. Cases might be dismissed. We'll get to that in just a second. Youth might be diverted after they've already been detained, or they're adjudicated not delinquent or placed on a less severe sanction like probation or something like that. But most youth who are being detained are not there as a result of a dangerousness hearing or being deemed dangerous, or which leads us to our fifth key takeaway in the data report, which was that racial disparities are worsening across many process points. And this chart, I think, does a really good job of just visualizing what's going on at our system at key process points when we're looking at racial disparities in the system. And you can see here, the blue represents admissions across different process points for Black youth. Purple represents admissions for Hispanic and Latino youth, and the red represents admissions for white youth. And if you take a look at all four of the process points highlighted here, you could see that the disparities that we see in our system are getting worse because of a decrease in system use for white youth and an increase in system use for Black and Latino youth between 2023 and 2024. So you could see that we saw decreases in system use for white youth across the arrest stage, the overnight arrest stage, as well as the first-time commitment stage. We did see an increase in system use for white youth who are detained pre-trial, but you could see that their rate is still not as steep as the increase in system use for Black and Latino youth. When we look at specifically, the board really focuses on the front door of the system, so this arrest phase here. this 14% increase in arrests for Black youth and this 18% increase in arrests for Latino youth. Meanwhile, we saw a 2% decrease in arrests for white youth. As I highlighted earlier on in the presentation, how youth come to court really matters because we know arrests can be traumatizing and are particularly difficult for youth in the system, and that summons is the preferred response. And we could see disparities in how youth are coming to the attention of the court. And so in fiscal year 24, compared to their white peers in Massachusetts, Latino youth were 2.5 times more likely to be the subject of an application for complaint. And when we look at how youth came to be the subject of an application for complaint, Latino youth were 2 times more likely to be summoned to court than white youth, and 3.3 times more likely to be arrested. And Black youth saw similar trends where they were 4 times more likely to be the subject of an application for complaint compared to white youth in general. And when we break it down as to how they're coming to court, Black youth were 3 times more likely to be summoned than white youth, and almost 5.5 times more likely to be arrested. So we see those disparities in how youth are coming to the attention of juvenile court. And Melissa will hit on this later. We're working on, the OCA will be publishing a brief on racial and ethnic disparities. The board has also reported on racial and ethnic disparities, specifically at the front door. And so it's something that we're continuing to dig into the data and provide recommendations for improvement in this area. One of the areas that shows us that many more Black and Latino youth can be diverted earlier on in the system is this chart right here. So data shows that a greater percent of applications for complaint for Black and Latino youth are dismissed or diverted compared to white youth. And so what does that mean? So if you look at this chart over here on the very right side of your screen, this breaks down the 2024 totals across process points for the estimated calculation of cases that don't reach a disposition. So kids are dismissed, their cases are dismissed or diverted for a variety of reasons. But when we do some back of the envelope math, we can see that 81% of all applications for complaint that come into juvenile court in 2024 were not resolved by a disposition. So they were dismissed or diverted in 81% of cases in 2024. That's for all cases. But when we break that down by race, we can see that a higher percent of Black and Latino youth, a higher percent of those cases are dismissed or diverted before that disposition phase compared to white youth. And so what this says is that there's a higher threshold for bringing white youth to court and a lower threshold to bringing Black and Latino youth to court based on the data, and room for diversion for keeping Black and Latino youth out of the juvenile court system. The sixth and final finding of the board's annual report was that there was a substantial increase in the use of physical custody for girls. This was the first year that the board saw some pretty remarkable increases in system use for girls. And I want to note that the higher rate of increases that you see on your screen is at least partially driven by the fact that the number of girls in the system overall is pretty small. Boys make up the majority of our juvenile justice system. And so percent change really can fluctuate a lot when that initial group number is really small. So that is one caveat to this. However, we do see some pretty stark increases. So applications for arrests increased 19% for girls between 2023 and 2024, and just 3% for boys. We can see an increase in overnight arrests, a 22% increase for girls, a 6% for boys. Pretrial detention admissions, there was a 49% increase in admissions for girls and a 12% increase for boys. And first-time commitments also saw an increase in system use for girls, a 10% increase compared to just 1% increase for boys. So really, yes, girls are still a smaller portion of the population of the juvenile justice system, but an increasing population across these custodial process points. So that was a lot of data. There's a lot more in the report if you are interested in learning more or getting into the nitty-gritty here. But just to recap, these six findings was that there was an increase to system use for a couple of years post-pandemic, but in 2024, across most process points, we did see this leveling off in system use in 2024. However, the use of physical custody is increasing across those physical custody process points. And that's primarily driven by an increase in admissions and arrests for lower level or misdemeanor offenses. And when we're looking at pretrial detention as our custodial process point, we could see that most youth who are detained pre-trial are not found to be dangerous and ultimately not committed to the Department of Youth Services. Racial disparities are worsening across many process points, and Black and Latino youth continue to be overrepresented across all of our process points in the juvenile justice system. And then, as I just presented, the significant increases in physical custody are also driven in part by an increase in system use for girls. So I'm going to pass it back to Melissa, who's going to talk us through what we can do about these trends.
Great. Thank you, Christy. So hopefully at least one data point and maybe more that Christy presented on today got you a little fired up, got you thinking about, okay, how can we address the system, this situation? How can we make things better for our youth? So that's what I'm going to talk a little bit about are some opportunities for improvement. Christy, if you want to go to the next slide. So first, there's always a little bit of doom and gloom right when we present data. I think particularly the very depressing data on racial and ethnic disparities that we continue to see in our system. But I also personally feel pretty depressed about the data about youth arrests going up. And I think maybe this year in particular, it can be easy to wonder, okay, are we making any impact at all? Is anything getting better? So this slide is going to be the first slide that says, some things are getting better. We have made some good progress in recent years. And so what this slide shows you is the reductions in the number of young people coming into the system following passage of the Criminal Justice Reform Act. And you'll see across the board, with the exception of arrests, the numbers are lower now than they were in 2018, fiscal year 2018. And that's a very good thing. In particular, we're seeing some pretty remarkable drops in the number of arraignments. So a 27% drop in arraignments, a 20% increase in pretrial detention admissions. Those are some pretty fantastic numbers to see. Now, do we want to see those numbers improve even more? Yes, we do. And we're going to talk about more of that in a second. But I do like to take a moment to just, share a little bit of good news before I go back to talking about all the things that aren't working. So with that, let's go to the next slide. So what can we do? If you've ever read a JPAD report, you'll know we have a lot of ideas over a lot of pages about things we can do. Today, we're going to focus on 3, and we're going to keep it pretty high level, but we will drop some links to the 2 JPAD reports that have come out in 2025. So that's our pretrial report that came out in January and our annual report that came out in March. And there's more details on all of this in these reports. But high level, what I'm going to talk about are how we can divert more youth pre-arraignment so that we keep them out of the justice system altogether. We're going to talk about implementing some of the pretrial reforms that we made recommendations on in that pretrial report from January. And then we're going to talk a little bit about police decision making and what are some actions that local police departments could take to try to reduce some of these increases in arrests and disparities. So next slide, please. All right, divert more youth pre-arraignment. Christy did a really nice job of high-level outlining the research on diversion. If you remember nothing else, remember that diversion works. If we reach the right kids and we provide them the right supports, they can and will be successful. And we can do that outside of the juvenile court system, which leads to better long-term outcomes for kids and also fewer cases for us to have to process in juvenile court. That's fewer resources that it takes from the Commonwealth as well. Diversion is much, much, much more cost-effective than processing a youth through juvenile court. Even if it wasn't more cost-effective, it's still a good thing to do. But in these tight fiscal times, it's nice to know when something is also cost-effective. So actions the state could take right now is support funding to expand the Massachusetts Youth Diversion Program. This is a program operated by the Department of Youth Services. It's been up and running for the last couple of years. It started with a pilot phase in 3 counties, and we're now really, really pleased to say that we are up and running in 9 counties. We just recently expanded to Norfolk and Suffolk counties, and I know that they're in the hiring process, so they'll be accepting referrals relatively soon. But we're otherwise operational in every county except for the Berkshires and the Northwest District Attorney's Office county there. We would like to be statewide, and we need just a little bit more money in the state budget to do that. The state budgets that have come out thus far would not support that expansion, but we're certainly hoping that over the course of this budget process, a little bit additional funding would allow for that expansion, and it would be really wonderful to take this program statewide. The OCA has done some evaluations of the program, and the success rate is really quite high. And hundreds of kids are being diverted each year now, which is wonderful, and let's do it more. Another way that we could divert more youth pre-arraignment would be to expand the list of offenses that are eligible for judicial diversion. So I mentioned that in 2018, the legislature created judicial diversion as an option, but they limited the types of offenses that judges could divert. And there is pending legislation that would expand that list. It doesn't mandate judicial diversion, it just creates the option. And so if a judge looks at a case and looks at the circumstances of the case and think it would be a good opportunity for diversion, they'd have that option. And so those are 2 steps that the Commonwealth could take to increase the number of youth that are diverted pre-arraignment. Next slide. So next we can talk about implementing pretrial reforms. We didn't get into it too deeply in this presentation because we had a lot of data to go through, but we did do a very deep dive of the pretrial system, including talking to lots and lots and lots of practitioners and youth. And I'm sure we talked to at least a few of you on this phone call, and thank you if so. And what came out from those conversations and study is that increasingly the Commonwealth is setting conditions of release for youth more often. And then many times that those conditions are not necessarily developmentally appropriate and not setting youth up for success. And so Christy presented the data on violations of pretrial conditions leading to more youth being placed in detention. We think that if a little bit more work was done to create conditions that support youth success and that are developmentally appropriate, and if we were also to provide some more resources in the community to ensure youth can be successful in that period, we'd have fewer kids entering detention on the other end. So some of those recommendations include providing more guidance on what do I mean by developmentally appropriate condition, right? What does the research tell us works for youth, and how could we implement that more often? We made some recommendations about changing the form used by the juvenile court. It's currently the same form that's used for the adult court. As Christy mentioned, kids are different, and creating a form that, if nothing else, was more readable for youth, we think could be a good step forward. We also recommend, providing more guidance on when should pretrial conditions be revisited, and how could we address violations in a way that is equitably done across the state, and again, sort of conforms with what we know about adolescent brain development. And then finally, we think we need a more well-resourced continuum of interventions for supervision for youth that, a judge might say, look, I'm not ready to release you on personal recognizance. I'd like to see some oversight, but perhaps if we could put some community services in place, we could keep that youth successful in the community rather than holding them in detention. Next slide. And then the last piece we want to talk about is around police decision-making. So Christy presented some data about how the use of arrests as compared to using summons is going up, that we're seeing arrests being used more often for misdemeanor offenses, and that we see significant racial and ethnic disparities and how arrests are used for youth. A lot of decision-making about arrests happens at the local level. And so although the state has certainly made some attempts to do reform at the statewide level, including passing the 2020 policing bill, for a lot of these reforms to take hold, it really is going to require change police department by police department. So the JPAD board has recommended first the 2020 policing bill. Much of it has been implemented, but not all of it. And so there are still some ways to go to implement the reforms previously legislated. In particular, we want to note that the Post Commission is currently in the process of hopefully establishing minimum certification standards for juvenile operations. That's sort of part of the legislation that's required. And I think many of us are waiting to see those standards come out, and we're hopeful that might provide a little bit more guidance, particularly on the use of arrest. And then finally, we're recommending that police departments look at their own data. The data that we're presenting here is statewide. And we don't have it broken down by individual police department. And so I unfortunately can't tell you, is this just an urban versus rural problem? Is this problem being driven by a small number of police departments and many other police departments are not showing disparities? I really don't know. But police departments do collect data on who they arrest, who they issue summons to, and they could do that internal analysis at their own level to see if they're matching these statewide trends or if perhaps they're going in a different direction. We also recommend police departments require officers to document why they decided to arrest a youth versus seeking a summons. If a summons is by law and by training supposed to be the default option, hopefully there's a really good reason when an arrest is used instead. And if we start to document those, we might be able to get a better sense of what those are. And if there's some reasons that perhaps we could move to a summons with a little bit more training. And then finally, we recommend that departments look at their own policies and practices in conjunction with their own data to see if there's any that are contributing to racial and ethnic disparities and if some of those could be changed at the local level. All right, next slide. All right, so just a few highlights about 2025 projects, and then we're going to have time for questions. So gear up. If you haven't put your question into the chat, this is your moment to go ahead and do so. All right, but if we'll go to the next slide. So first, I want to let you know, so stay tuned. OCA has a couple more data briefs coming out. They're going to expand on some of the key themes that Christy talked about today. This data can be dug into a lot deeper level, and we're excited to do that and are in the process of doing that. Some of the questions that we're hoping to help answer, or at least get closer to an answer with in these data briefs, is to try to get a better sense of what is contributing to the racial and ethnic disparities that we see at the arrest level. Try to dig into why there was such an increase in system use for girls and what might be driving some of those trends so that we can think about better ways of addressing them. And then we also want to look at geographic differences. So I said a moment ago, we don't have data on a town by town level, which is true, but we do have data on a county by county level. And when we've done county level analysis before, we see things look really, really differently in different counties. And so we want to see what that looks like for 2025. Next slide. And then finally, the JPAD has been involved or has been leading a multi-year project focused on dually involved youth. So these are going to be youth who have an open case with the Department of Children and Families, so DCF involvement, at the time they become involved with the Department of Youth Services, whether that's through a detention or a commitment. The numbers go a little bit up and down every year, but generally speaking, for a rather long time, about half of all detention admissions are for youth with DCF involvement. That's a lot of those detention admissions. And when you really think about the level of trauma and challenges that many of these youth have received, it really sort of begs the question of what else could we be doing to keep these kids out of the justice system? And so this project aims to get at exactly that. We are and continue to interview a lot of people. We're doing a much deeper data analysis, including a case file review to try to answer some of these questions. And we hope to have a report out later this year with some recommendations about how we can better support these youth and hopefully avert justice system involvement. All right, next slide. We want to hear from you. If this presentation has raised any questions or ideas, or you just want to share your experiences, you can contact us anytime. Christy's email is right there. And you can also just Google JPAD board and you'll find us that way as well. Next slide. Okay, and I think this is our final one before we do questions. If you thought, my gosh, that was not enough data, I have good news for you. We have much, much more data on our juvenile justice data website, and we'll pop that link into the chat as well. And this website is interactive, and so you can sort of cut things in different ways and help answer your own research questions if you have them. So we invite you to check that out. And then with that, I think, great. Christy, do we have any questions in the chat?
Yep, we have a couple so far. So Afton asked a bit about this 68% spike between 2022 and 2023 in pretrial probation and supervision, and any understanding as to what drove that. And Melissa, if you want to add on, I did want to respond to Afton that we don't have exact data to say what is exactly driving that. However, we do see that judges are using conditions of release more than personal recognizance in 2024 compared to prior years. So we're seeing that shift in we're using conditions of release more in cases that might have been released on pretrial or excuse me, personal recognizance, as well as a shift from pretrial detention to conditions of release. So there is a couple different factors weighing in there, but Melissa, I'm not sure if you wanted to add anything to that.
Yeah, I feel like this is $1 million question. When we saw that data increase last year, I thought that's a big increase. Like, and some of it was coming off the pandemic, and we've seen increases across the board in system use post-pandemic. But that was a pretty big one. I don't think we really know. I have some hypotheses, and I'll share one of them with the caveat that this is not actually grounded in data, just observations about the system, which is that the 2018 Criminal Justice Reform Act created a pretrial services division and tried to sort of standardize a practice at probation that was happening maybe a little bit more informally and a little bit different from jurisdiction to jurisdiction. And that, of course, takes a little bit of time to stand up. And then we had the pandemic. And so one hypothesis I have is we built this system, which I think was built and continues to be built with the absolute best of intentions of providing more support pre-trial so folks can be successful and hopefully avoiding the use of detention or jail on the adult side. But is that because that system now exists, are judges feeling like they ought to utilize it more? And so are they setting conditions of release a little bit more often than they were before because they have this supervision option? Again, we don't really have the data that tells us that, but I think a lot of experience looking at how the justice system operates. We do know that there can be something called net widening, which is that when you build a new option, people will take advantage of it in good ways and in ways that can be challenging. So that's my hypothesis, but we continue to dig into that. Yes, Afton, you put in the chat, if you build it, that will come. That might have been happening. But I invite other folks in the field to pop your ideas into the chat. I see a lot of folks here who frankly have more years of experience working the juvenile court than we do, and you might have some thoughts. And Christy, before we do the next question, can I just ask someone on the team to post the links to the reports in the chat?
Yeah, Ariana, if you can grab those links, that would be great.
Thank you.
The next question is from James, who said, mental health clinician here. Welcome, James. Happy you're here. He said, is there any specific advocacy happening to recommend developmentally appropriate and evidence-informed diversion and probation stipulations? He said that mandatory therapy is rarely effective, and POs, probation officers, wanting details on clinical information or recommendations does prevent trust building with youth clients.
One form of advocacy is the report we put out. We agree with you, right, on a lot of what you're saying. In the report, we made a variety of recommendations. One of them, in particular, was to do training of combined training, including judges and district attorneys and defense attorneys and probation officers, really talking about the research and what research tells us is going to be an effective condition and which ones aren't. One thing I've noticed is it takes a lot of time to pay attention to the research. It takes a lot of my time to follow it. If I am a practitioner trying to hear cases or prosecute cases or defend kids, I don't always have the time to keep up on all that research. And so I think we could really do the system a benefit by presenting that research to practitioners in accessible ways. And I think that could help change practice. And part of the reason why I've got some hope around that is that our colleagues at DYS did just that exact same thing with the JDI movement, I think well over a decade now. A ton of work went into talking about the dangers of detention, and the use of detention went down, right? So if we arm people with information, I firmly believe the vast majority of people are looking to do the right thing and the effective thing. So all that is to say, we are certainly advocating for that. And we certainly invite other folks to advocate for, it's training and additional guidance. And we're going to keep tracking the data and see if any of that makes a difference.
That's it for questions in the chat. If folks had other questions, so feel free to unmute.
Good. Well, I will again just thank you for taking an hour of your day to be with us here today. We will send out a copy of the recording and the slides, so you'll have that. And we are always here. If you've got questions about data, if you've got ideas, please do reach out. We really love to hear from folks, and just appreciate your interest in the system. So thank you very much and have a wonderful day.